Hello again, everybody. This is attorney Mark Brunner. Thank you so much for joining me again here today on Talking Texas Law. Well, today let's talk about jury selection, or what we call here in Texas, voir dire. And so already right there, with just that phrase, you know you're in Texas. Everywhere else in America, they call it voir dire with the proper French pronunciation. But obviously here in Texas, we have our own twist on everything. We got to call it voir dire. So if you go to any national conference, they're talking about jury selection, and you say the phrase voir dire, you've already kind of outed yourself as a proud Texas practitioner of law here. So let's talk about voir dire, jury selection here in Texas, and some of the aspects about it that may or may not be unique to the state of Texas. Here in Texas, the right for a litigant, either civil or criminal, to have a jury is enshrined in our Texas Constitution. Both sides of a conflict have an absolute right to ask for a jury trial, and that includes also in a criminal prosecution, the state of Texas. They too can ask for a jury even if a defendant, let's say, does not wish to go in front of a jury. The state of Texas retains that right. As a criminal law practitioner, I'm going to be talking a little bit more about the criminal law aspect of jury selection of voir dire here in Texas, and so the focus is going to be a little bit on that as well. In all cases, whether you're talking about a civil or a criminal trial, jury selection really is a misnomer. It is what I like to call jury deselection. We are not picking people from that jury panel like you're picking for a, kickball team when you're in your elementary school. I'm going to have this kid, now it's your turn, you pick that kid, now I'm going to have this one, you pick that one. That's not how jury selection goes. Really, it is a winnowing out, it is an elimination of certain people from that jury panel, and then we are getting whoever is left. So that is really the deselection process, and we'll talk about that here in a minute. Let's talk first about some general overviews about the criminal voir dire jury selection process here in Texas. So for a felony, a crime punishable by punishment up to imprisonment, not just county jail time, but for any sort of felony, we're talking about getting a jury of 12 people. For a misdemeanor, you're talking about a jury of 6. So misdemeanors for county jail time, felonies are for imprisonment at the Texas Department of Criminal Justice. So 12 for felony, 6 for a misdemeanor. So right there, you're going to see that there are some different dynamics. Generally, there is no magic number for who gets summoned for jury duty. It really depends on the county. It depends on how many other trials are maybe set that day. A courthouse may have many trials going on at the same time, and so that county clerk's office who summons the jury may have reason to have summoned multiple people, and they just see who shows up and then assign them to the various courts. So important to the how you get down to the number of people, the 12 for a felony or 6 for a misdemeanor or whatever we have for various civil cases, is the process of what we call strikes. A strike is a peremptory strike, peremptory challenge is what we call it, is the ability of either side to strike someone who they don't like from the panel, really for no reason whatsoever. It can't be a discriminatory reason. I can't say based on someone's sex or their racial profile or what have you. I can't discriminate on a strike on that basis. That would be unconstitutional. But for really almost any reason whatsoever, I can strike someone who I don't feel is going to be a good match for this particular case. And again, both sides get a chance to do that. Well, how do you know who to strike people? Well, that's through that voir dire process. Voir dire is really both sides having a chance to approach that jury panel, maybe 30, 40 people for a misdemeanor. If you're lucky in a big county, it may be 60 to 80 to 100 for a felony if it's a major or controversial crime. It depends. So you have a conversation really with that panel of people. The judge will have started by asking some of the folks if they've got any sort of excuses. Maybe someone's not really authorized under the proper statute to be there. Let's say they have a criminal conviction for theft. They've got a pending, or they got a felony conviction themselves. They may be too old for the process, and there's people that there's nothing in Texas that says beyond this age you cannot serve. It's just that you may be asked, you may be allowed to get off if you're beyond a certain age, or you've got care for a small child, you've got other things that will distract you from your ability to serve. So with that in mind, so what would happen then is each side has a chance to speak with the panel as a whole, ask them various questions. The people may raise their hand, they may indicate one way or the other in the responses to the questions. So what the lawyers on both sides are doing is trying to identify people that would be good or, more importantly, bad for their case. Because really, again, you can't say, gosh, I really like juror number one, I want that person, I'm going to select them. It doesn't really work like that. It's a deselection process. You knock out the people you don't like and hope that that juror number one is still there at the end of the day. So again, both sides have a chance to ask the jury various questions. The judge may impose time limits on that dialogue, and that can be tough sometimes. And so sometimes litigants really have to fight with the judge about what they think is an appropriate amount of time. Sometimes you have a very talkative jury panel, and that litigant sees their time just being ticked away by some of the question and answer back and forth, and may need to go to the judge and say, hey, judge, please, I need more time to explore these topics. So with that in mind, again, both sides have a chance to poll the panel, ask them various questions, take notes on who said what, and then what will happen is once at the conclusion of that voir dire process of both sides talking to that panel and asking questions and getting those answers, both sides will then approach the judge, and then the judge and them will have a conference. Which happens there is they're trying to identify people who have, by virtue of their answers, said something that has made them, again, not qualified to serve on this particular jury. Let's say it's a criminal case, and we've got a juror number two that says, I'm going to believe everything a cop says when he gets on the witness stand. There's no way I'm gonna disbelieve what that officer says because I know they're sworn to tell the truth. Well, a defense counsel may say, Judge, as a matter of law, they're supposed to handle all witnesses, give them all the same credibility, and they're already saying that the state's witness, a police officer, is going to start up here, and they're never going to bring their credibility down, so this person can't be fair as a matter of law. And that's really the magic language. As a matter of law, this person cannot be fair. The judge may agree and decide to strike that person. That person's going to be gone from the panel, not right that second, but later through the selection process. It could go both ways. Someone else could say, hey, I'm juror number 5. I think the cops in this jurisdiction are crooked. I don't believe them. And you're telling me that the state's going to have officers on the witness stand. I'm not going to believe anything they say. So sort of like the polar opposite of the other scenario. So there the state may tell the judge, hey, judge, juror number 5 said they're not going to give any credibility to any witnesses. They're supposed any of the state's witnesses. If they're police officers, I've got officers as my witnesses. They're supposed to treat them fairly, and they can't. Treat them with an open mind, and they said they can't. So the judge may, again, call people up there, ask them some more questions, verify that they did say what they said, that their positions are essentially unshakable. And again, if someone has that kind of bias or can't keep an open mind about an important facet of the case or can't follow the law, then the judge can strike them. So then after the judge makes his strikes of the panel, you really have whoever's left over, and then both sides retreat off to their own respective corners and then secretly make their peremptory challenges. So each side in a felony case will have 10 peremptory challenges, meaning they can strike whoever's left for any reason they want to. For a misdemeanor, they have 3 peremptory strikes. So again, the ability for both sides in secret to make their strikes. Really then what will happen, both sides will hand their strikes to the court, the clerk of the court. He or she will note down who the judge has struck, who one side has struck, who the other side has struck, and then look at the list of the jurors. And really then it's whoever is left in numerical order. They get selected. That becomes your jury panel. 12 for a felony, 6 for a misdemeanor. For civil cases, it differs. But it's those first people that whoever's left becomes your panel. So again, not a selection process, not the ability to handpick certain jurors. You may be in love with juror number 60 all the way in the back of the panel, but guess what? If not enough people get struck, you may never get back to juror number 60. That person may never be on your jury. So you're really looking at the people towards the front of the array of folks that have shown up for jury duty that day. One thing here in Texas that is allowed that can help this voir dire process and speed things along is the use of questionnaires. Jury questionnaires have to get permission from the court, and these have to be distributed either to the jurors in a meaningful amount of time to where the litigants, both parties, can get the answers to these questionnaires back and have time to really study them. So these questionnaires usually go beyond matters of simply the basic information that the clerk will collect on everybody. Name, are you married, education level, how many kids you have, have you been a litigant before, have you been served in a jury before, civil or criminal. I mean, just some very basic information is all that we typically have to identify these jurors. We really know nothing meaningful about them. Sometimes a judge will allow questionnaires to probe a little deeper. The court, of course, will have to approve those exact questions, but sometimes they will allow both sides to learn a lot more and then can speed things along. So it may be things such as hobbies or interests. Do people hold certain political views? Do they watch certain television shows? All these things seem a little trivial, but they can have very good insight into who these people are in front of you and what they may be thinking about a particular case. So with that in mind, again, you get the folks who, we joke about this a lot of times, you're judged by the people who have not really expressed an opinion. The folks who have said the most in the voir dire process, who have identified and taken a stand one way or another on some of the issues, those are the people that more likely than not have said something that one side or the other may not agree with, and those are the folks most likely to get struck. So a lot of times you'll end up with the 6 or the 12 silentest, quietest folks on that jury panel, because if anyone said anything controversial, there's a good chance that they may have been struck. There are provisions when using your peremptory challenges that if you have burned through all that you have, you're allotted 3 or 10 strikes, and you feel that there's people on the panel that would be put on the panel that you still have problems with, you can always ask the judge for more strikes. They don't have to grant that, but it becomes maybe an issue on appeal, so sometimes the judge will grant additional strikes to both sides in order to kind of placate some issues there, but that's rare. But again, that's our process in Texas for criminal cases, criminal voir dire, and a very important aspect of the overall litigation scheme, and because that's going to identify your audience, who you're going to sell that case to, whether you're the state, whether you're the defense counsel, or in a civil matter. These become the people that you need to persuade in your case. That's voir dire here in Texas. Thank you so much. And our usual disclaimer, this video is being offered for informational and educational purposes only. It's not to be construed as giving specific legal advice, and this is not a legal consultation. And unless you are already a contracted client of mine, I'm not your lawyer. This has been Attorney Mark Brunner. Thank you so much for joining me today on Talking Texas Law. I'll see you all next time.